Hello, everyone. Welcome to Court with Krissy. Here are 4 court shorts you probably didn't catch. And I'm kicking it off with my favorite first. I learned something. Who knew that a kangaroo court wasn't meant for marsupials? Crikey. It's not even Australian. I hope you like it. Court with Krissy is now in session.
All right, we're going to go ahead and start from the top. Mr. Anderson, Keegan Anderson, if you're present, unmute yourself.
Present.
There we go. All right, Mr. Anderson, you are here on a citation for speeding 50 miles over the limit. You heard the information about the deferral program. Are you wanting to enter that deferral program?
No, I do not, but I do have a different question.
Okay.
So I was told that I had to appear in the actual Cowlitz court, the building itself, and then they told me that I had to be a part of the Zoom call. So I was asking if there was any kind of request option to have a live courtroom where I actually stand in front of a judge in the same room.
No, we are doing all infractions via Zoom.
There's no way you guys could set a motion for that?
The courts are very busy, and we don't have a whole lot of courtrooms available. So infractions are held via Zoom.
Okay, I just don't feel comfortable with that because that seems a little of a biased way to do it, and plus that kind of falls into the jurisdiction of Kangaroo Court, and I just would like to request the right to a fair trial in person. I mean, there also is a court house down in Vancouver where I'm from because I had to drive an hour up north just to be here, just to be on a Zoom call.
Okay. So are you wanting to proceed with your contested hearing?
I guess that's my only option at this point.
Okay. At this time, since you are contesting the state's allegations, I'll let you proceed with providing your evidence and information.
Well, pretty much the story was I was heading southbound, coming home from Cathlamet, Washington for my church Bible camp. And I was on a road that was about 25 miles an hour. It was a snake pattern road and it was raining. And by the time I came to the clearing, I came onto this road where it was 50 miles an hour and I was driving 45. And then the state trooper, Officer Krissy, pulled me over and told me I was going 75 in a 50, which was completely asinine and not true. And he failed to provide me evidence on his radar gun that I was going that speed. And he also said that his radar gun worked by sound. So he said that my car was heard by a sound radar before he even saw my car passing him. And he still failed to provide evidence of even that claim. And then after I provided my license, registration, and insurance, he went back to his car and he came back with a traffic infraction ticket for speeding 15 miles and over in a 40 mile an hour zone, which also is not correct. So are you still there?
I'm here.
Okay. I lost a visual of you, so thought I'd ask. But I'm contesting today for a 100% reduction of a crime I did not commit. And I would like to go about my day.
Okay. Let me just quickly read through the report here.
I already paid. That's what I want to know. It's already paid. Well, it's already paid. I got the receipt. I paid the same day.
So you paid the same day. They mail it out afterwards. You have a copy of the judgment, but you've already paid and closed.
Okay.
All right. Having read through the report, does look like
You don't need that receipt. Okay, thank you.
Trooper Kreitz does indicate that the radar unit had been calibrated both before and checked for accuracy with certified tuning forks before and after his shift. And the speed that he monitored was consistent with vehicle speed. So we are going to find that committed, and Let's see here.
And then we waited in line at Impel for like an hour.
That is a fine of $170. We will send this this information to you, and you'll have 60 days to make payment or make payment arrangements with the court. You'll get this in the mail. And if there's any question about whether or not we have your accurate mailing address, go ahead and call the court clerk and make sure that's updated with them.
Okay, so who would I would talk to about the right to accuse you of a mistrial?
I'm sorry, say that again.
So who would I contact about mistrials?
You'd have to consult an attorney. I can't give you any legal advice on that.
Okay.
These are all 7 cases that are.
Any other questions?
You have my email address?
No.
Do you have my mailing address?
Mailing address in Vancouver.
All right.
Okay.
Well, I suppose that's the end of my hearing.
Okay. Thank you. Have a good day.
Have a seat right there.
Thank you.
State your name.
Santiago Rosales. Pablo Santiago Rosales.
Good afternoon, Mr. Rosales. We are
Hey.
on the record in case number 25-5098S, 5085SM. You're appearing for arraignment purposes this afternoon on a bench warrant. You're appearing with your attorney, Mr. Henney. And Mr. Henney, have you had opportunity to speak with Mr. Rosales?
Yes, I've talked to his family, and Mr. Rosales did in fact go to court on this date. He checked in with the clerk, but was misinformed by the court clerk that he did not have a case that day and was told to go home. I believe there was also a mistake on the notice to appear. Our office had an attorney covering for us who did not do a proper job looking for the defendant, and after only checking one other person, assumed the defendant did not show up, even though he actually did. And this was the covering attorney's mistake. We have been contacting the court explaining that the defendant never met with his attorney that day. This is not the defendant's fault, but he was misinformed by the court clerk when he was at the courthouse the day of his hearing and was mistakenly told to go home. Your Honor, we respectfully suggest, if necessary, to look at the court video camera from the court to prove that the defendant was in the courthouse and checked in with the clerk that day. Our office has been contacting the court many times to figure out what happened and resolve the issue, but was told the defendant had to turn himself into jail. Additionally, he is innocent until proven guilty, and he is innocent of these charges. The alleged victim has provided a letter indicating she hurt herself and she lied. There's not a legitimate case against the defendant, and he should not be locked up because he attempted to comply with all court requirements and was in fact present on the court on the day of his hearing. We kindly ask for him to be released from jail with no new bond conditions.
I'm just looking at one other place, if you would hold for just a moment, please.
Absolutely.
Okay, so information that we have. So I just want to make sure that I'm understanding what you're saying and to see if that matches what we have. That the defendant did show up, but he was told by somebody here in the court that we had no case, but that he had met with his attorney at the courthouse.
Your Honor, that's actually false. Our office manager provided the wrong information to the court. He never met with his attorney. I'm understanding, yes. His attorney looked for him and questioned one other person, and when that person wasn't the defendant, he assumed the defendant did not show up. But from what I understand, the defendant talked to the security. They told him he didn't have a case. They talked to the court clerk. They told me he didn't have a case and to go home, but he was present.
Yeah, I was, and I didn't go to talk to any lawyer, just to the officials on the entrance.
And did you talk to a court clerk?
Sorry,
or
what's
just the security?
There were two persons at the security, well, at the entrance. There was this officer and another person, and that person double checked because I remember he asked me for my complete name and I told it to him. He told me I didn't have any case and I went home.
Mr. Royals, did you check in with the court clerk?
Yes, I'm pretty sure. Well, I didn't went in. I asked there, and yeah, it should be registered. There should be cameras of when I was there on Tuesday around 1:50. Yeah, I talked to I don't know who's the clerk, to be honest, but there was a person there and an official. So I talked to an official and another person who I don't know if it's the clerk, but that person said he was checking if I had any case, and he said no.
Okay, so you didn't make it past the security officials, correct? You didn't come into the court.
I was on the building. I was on the building, but
Right.
I didn't pass the check because they told me I didn't have any.
Okay. All right. So, Mr. Henney,
Yes.
the bench warrant, Mr. Rosales has the ability to admit with an explanation, say, yes, I'm guilty, but this is the reason what happened. Or he can deny that he's responsible for having failed to appear for that final conference and request a hearing. So how is it that your client is going to respond?
What would you like to do, Mr. Royals?
I mean, I'm innocent. I presented to the court. Why can't that be just checked right now?
Your Honor, if we went to the option of denying responsibility and setting a hearing, how would that proceed?
We would schedule that on the judge's docket as quickly as possible. I don't know. We would not have that date for you today.
Okay, considering that the defendant was at court, I think we're going to deny responsibility and continue with a hearing. Is there any way he can be released from jail today?
The court's concern is we have not had full disclosure. We have not had information from your office as well as from, well, hopefully now the defendant is truthfully letting the court know what happened. But there's been certainly a mix-up from your office. And it would be highly unlikely if security officers would say anything with regard to a person having court or not having court. I can tell you it was not, the final conference was not scheduled at 1:50.
It was scheduled at 2 o'clock.
And he said Monday, right? You were here on that Monday, is that what you said?
No, I think I said
Mr. Rosales.
Tuesday.
Okay.
Pretty sure it was on Tuesday.
It was Tuesday.
So did you appear? I'm sorry, go ahead.
It was Tuesday 10-28 at 2 p.m. and I believe he was there at 1:50, and he was in the courtroom and ready to go to court and was told that he didn't have court, so he trusted what he was told.
He was not in the courtroom, Mr. Henney. You need to get the facts straight as well. He made it to the courthouse. He made it to security, which is at the entrance of the courthouse. He didn't
Understood.
make it past security. He was not in the courtroom on the final conference day. He was in the court on the pretrial date, however, so he knew that it didn't end with the security officer, or should have known. Pretrial was scheduled on September 18th at 9:30 a.m.
How would I know that it didn't end it there? I have that question because I mean, if officials at the entrance tell you to go back, I don't know how. Like, what did you expected me to do? To tell them, yeah, I do have
So
one.
that's something you can discuss with your attorney, Mr. Rosales. You were here for the pretrial conference. The pretrial conference would have been exactly the same process as a final conference, just at a different time. Pardon me?
That I was there for the other one too. I just didn't pass security because your security told me to not pass. If they would have told me I had something, I would have passed.
I don't,
Okay.
Your Honor, what I think the client's
That
saying is
again,
that, go ahead.
you're welcome to discuss that with your attorney, Mr. Rosales. Mr. Attorney, Mr. Rosales will be remanded to jail until the time of the hearing. We'll get it expedited. And for right now, then you are all set.
Okay.
Thank you, Your Honor.
You're welcome.
Thank
You're
you,
all
Wade.
set, Mr. Rosales.
Stand right here for me, please.
There you go. This is 25 RO 02127. This is a speeding ticket that was issued on April 11th, about 10:30 in the evening on Woodward near Webster, and you were cited 60 and a 45. You can admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
I deny responsibility. I don't believe I was speeding at all. And based off of the
You could
original,
raise your right hands, please. Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
yes,
Okay, the officer will testify first, please.
Okay, so I was going northbound, Woodward, while the defendant was going southbound. I had my front moving opposite radar on, so I was reading the southbound traffic. I got a reading of his vehicle at 60 miles an hour in a 45-mile-an-hour zone. After he passed my vehicle still going southbound, I activated the rear radar, which also confirmed the same speed as when he originally passed me, at which time I followed him for a little bit and then eventually pulled him over.
And what can you tell me about the radar, please?
One, I'm certified to use the radar, and before the shift starts, we test the radar to make sure it's functioning properly, and then at the end of our shift, we also make sure it functions properly in between traffic stops.
Thank you. Mr. Cartwright?
yes. When the officer pulled me over, there were two things that he said that weren't related to speeding. I was moving in and out of the lane. I wasn't staying straight in the lane. That was the first thing. And the second thing was that he believed that I was under the influence of alcohol, which was a major issue on my end, considering that he gave me the breathalyzer test and I blew a 0.00. That is concerning to me because this is my third time this has happened in Royal Oak, where I've been pulled over and given the breathalyzer test, and I come back clean, and it's end up something else. It's always, well, you were speeding. So I just have issues with that personally.
Well, if they see a car speeding and they see a car weaving around in the time of day, you think it's a surprise that they might think that somebody that was driving like that would be drinking?
Well, no, because if you don't believe that you're speeding, and first of all, I have a car that doesn't even allow you to just move into another lane and swerve around. The car that I have doesn't even allow that. So that's the first indicator. And two, the fact that it was said that I was smelling like liquor and then I blow a 0.00, it's a low level of credibility for me. Now, had he had pulled me over and said that I was speeding, and then that would have been the gist of the call, then I would have a little bit more credibility in that particular situation. But saying that I'm under the influence and then saying that I could be drunk and to find out I blow a 0.00, I just think there's some credibility issues to me.
When you say that there's credibility issues, do you mean with your credibility or with the officer's credibility?
With the officers, I mean, if it appears that I am under the influence of liquor and you say you smell alcohol, that was also something that he said, was that you smell like alcohol. And I didn't drink. I didn't smell like alcohol, and those two things raise a sense of concern. And the fact that I get pulled over, and this is my third time taking a breathalyzer test in Royal Oak, which I've never been guilty of any of those things, it concerns me about credibility. I'm not saying the officer is incredible. It just concerns me that there's some other issues, especially at 10 o'clock when there's a million young kids driving down the street, making noise and speeding. I'm the one that's being pulled over. I don't understand. It's just concerning to me. You know, I love Royal Oak and I like to be in Royal Oak, but I get pulled over so many times in Royal Oak, and it just concerns me about, you know, reasons of me being picked on or however, whatever, you know, however you want to look at that. It just, I don't understand why it's okay to give someone a breathalyzer test. And by the way, if I was drunk, he forced me to go all the way to the right lane in the middle of traffic where a car almost ran into me. Um, Now, mind you, if I was intoxicated, that would be a terrible decision. So we went from the first left lane speed lane, or you want to call it the third left lane, and he tells me to start my car again and merge over to the right while there's traffic, and one car actually almost hit me. He had to put the lights on. I mean, it's just, I don't know, but maybe that's just the way they do things. It's just concerns to me, and I wanted to speak freely. That's why I didn't get my lawyer involved, because I am concerned about, you know, this experience and my continuous experience in Royal Oak.
The only thing you haven't spoken about is your speed.
Well, I said that I don't believe, I did from the beginning. I said that I don't believe I was speeding, because that's not the first thing that he said. The first thing he said was I was swerving in the lane, or I was swerving around between lanes. And then the next thing was, you smell like alcohol. So, I mean, speeding wasn't even a conversation. I don't even recall that being a conversation. I'm not saying it wasn't. I don't recall that.
Okay. The officer is certified to operate radar. Check the unit before and after a shift. It worked at the beginning, it worked at the end. He measured your speed with his front moving radar at 60 miles an hour in a 45 zone. He then measured your speed with the rear moving radar. It stayed at 60 in the 45, and he wrote you for that. And the conversation about weaving isn't on the ticket. The fact that you took the preliminary breath test and showed that there was no alcohol is really a good thing. So that saved you some issues. And the bottom line here, you didn't think you were speeding, but he measured your speed twice with radar, and it didn't change. Two different modes on the radar. So you have paid a bond on, I do believe you're responsible for the reasons that I just said. And you've paid the bond on this matter, so the bond will be applied. That's
fine. Just stop pulling over black people, officer, and saying they're drunk. Because I honestly don't understand this at all. Why you would give somebody a breathalyzer test when they haven't
Why
been
would
drinking
you
and they
drive
pour
60 miles an
0.0.
hour on Woodward Avenue and expect
I
not
don't
to get
believe I
stopped?
was, and no, you or anyone else can tell me differently. I don't believe it.
Well,
But
then
that's,
there's no
you know,
point in talking. There's a
Hello,
screen name, Samsung. What's your name?
my name is Aaron Brandon Williams.
Okay, your ticket is 25 RO04911. If you would turn on your camera, please.
I believe I did turn my camera on.
No, your camera's turned off, sir.
Okay,
There
is
you
this
go.
better? I was looking at you and then the screen zoomed out and everything.
Okay, the ticket goes back to July 30th. It was issued about 1:28 in the afternoon in the area of Royal Oak near Lincoln and Knoll Street. You were cited for speeding 30 and a 25. This is how the citation was issued. You can admit or deny responsibility, or you can admit with an explanation. How do you wish to proceed?
May I admit with an explanation, Your Honor?
Certainly.
Okay.
Absolutely.
I do apologize to the great citizens of Royal Oak and you guys as a police team. I'm sorry that I misread the sign and sped a little bit. I'm a good citizen, and it's not my intention to break any laws. I'm very responsible, and it was just a mistake on my end. So I do apologize to anybody that was affected. Or
That's
any
what a civil
recourse.
infraction is. You know, it's not a crime. It's
Okay.
a civil infraction. It's a mistake. There's no intent to do evil in a civil infraction the way there is in a crime.
Okay.
No, it's a mistake. And I've read the average driver commits a civil infraction every 3 blocks.
Understandable.
Yep. Is there anything you want to add to this, officer?
I'll make a motion to amend the ticket to impeding traffic.
Great. The advantage to you, Mr. Williams, on that is that there's no points for impeding. Do you have any objection to that amendment?
Not at all.
I didn't think you would, but I have to ask. So impeding is 175 and no points.
Okay, I greatly appreciate that. How long do I have to pay it?
What kind of time do you need?
About a month or less.
I
Is that
can
acceptable
go
to
30
the board?
days. Yeah.
Okay, I will
We
have
can
it
go-
within 30 days.
Okay.
Thank you so much, Your Honor. Thank you,
Thank
officer.
you.
And I apologize to the citizens of Royal Oak.
Not a problem. Have a good day, sir.
God bless y'all. Thank you.